2021 second stage. I now call on Deputy Paul Murphy and other independents and parties technical group to move the bill.
Yeah, thanks a lot, Cathaoirleach.
You're welcome. You're ready to move that?
I move it. Yeah.
Thank you.
The general election campaign for Fine Gael got off to a very bad start because a video emerged of Michael O'Leary launching the election campaign of Peter Burke, now the senior minister responsible for this area, including, unfortunately, responsible for workers' rights, and saying the things that Fine Gael and Fine Gael supporters say to each other when they think that there are not videos on and these things are not going to be public. Michael O'Leary endorsed a government led by Fine Gael and Fianna Fáil and said, let's put two parties back in government that can deliver. He said, we need a government that delivers for enterprise. It's vital we elect a government that gets shit done. And I can think of nobody here, certainly in the current government, who demonstrates more action, more energy than Peter Burke. Michael O'Leary, of course, being a notoriously anti-worker, anti-trade union employer. And, you know, the investment and the support of Michael O'Leary has paid off. So far, in just over 100 days of this government, you have had anti-worker measure after anti-worker measure pursued. Previous commitments made being dropped, the extension of sick leave, which we were promised at the time. We wanted to stitch it into the legislation, the increase of sick leave, and the government argued, no need to stitch it in, don't worry, we'll do it, now being delayed and proudly trumpeted by Fine Gael to business that they are delaying it. The delay of the promised living wage, just saying that people on the minimum wage should have the very, very basic what they need to survive, no longer a commitment by the government, kicked out, and also kicking off something that this Dáil voted for, which is to end the outrageous situation of so-called sub-minimum wages, of super exploitation of young people legally being paid even less than the minimum wage. So we have a government that is very, very consciously working against the interests of workers and for the interests of big corporations and the likes of Michael O'Leary. And the situation then is a country where we have immense wealth, one of the richest countries in the world, and yet we have the highest rate of low pay in the European Union, 1 in 5 workers being low paid, over 420,000 workers. On top of that is the 1 in 10 workers who experience bullying or harassment, is the conditions of precarity, where employees here work longer hours, have fewer holidays and have less protection against dismissal than their European counterparts. That is rife, and it is part of the so-called voluntaristic model of industrial relations that the government trumpets, which tries to make it difficult for trade unions to organise workers and for workers themselves to get organised. I'll give you an example. The people who are operating the cameras for the Oireachtas right now are an example of the kind of conditions of precarity. These are workers doing a job they should be directly employed by the Oireachtas. They're not. They are outsourced. They're in a situation when there was no Dáil for the extended period, when the election was called and when the government negotiations were going on, they weren't getting paid at all. The rates that are getting paid is about half of what the normal freelance rates would be for camera operators and the other work that is being done. It's absolutely scandalous, but it shows that this is absolutely rife in terms of bad working conditions for workers. And those same workers, of course, are faced with grocery prices that are still sky high, energy prices that are still sky high, and rent that is rising at a rate of about 10% a year. The best way for workers to deal with all of those challenges is to get organised into trade unions and to fight for better terms and conditions, even with the terrible legal regime that exists in this country, even with the horrific elements of the 1990 Industrial Relations Act, all the evidence shows that if you get organised in a trade union, you'll be able to combat bullying, you'll be able to combat discrimination, you'll be able to improve the atmosphere, improve your safety in your workplace, and you'll be able to increase your wages. All the evidence shows that there is a premium of being in a union of at least 10% in terms of wages and a series of other benefits. And the benefits of high levels of unionisation go outside of the workplace. Again, all the evidence shows that where you have higher levels of unionisation, you have lower levels of inequality and wage inequality right across the economy. Where you have higher levels of unionisation, a greater share of the value that is being created by workers goes to the workers themselves as opposed to going to profit. A key reason that the balance has shifted for more and more of the wealth being created going to corporations is this attack on trade unions, which kind of heralded by Thatcherism, Reaganism, and so on. And the consequence is that while workers in the 1970s were getting 55% of the value that was being created, that has been driven down now to 40%. So workers, even under the current regime, should join trade unions, should transform them into being fighting democratic organs. But we should be clear that we have a government that is working against workers getting organised in trade unions. I got a recent answer from the junior minister, Minister Dillon, asking about if he was aware that large employers in receipt of government contracts, I was talking about Abtran and Relate Care, who are anti-union employers. Abtran refuses to engage with the industrial relations machinery. Asking, they're refusing to recognise trade unions or engage in collective bargaining, and what the minister is going to do about it. And the answer I got is the answer that we'll get, I presume, in the speech from the minister in 13 minutes time, which will be to say that we have a voluntary system of industrial relations that is premised upon freedom of contract and freedom of association. The government fully supports the right of any worker to join and be active in their trade union. Employees have the right to form associations and trade unions, and an employee cannot be discriminated. But under Irish law, there is no requirement for an employer to recognise trade unions for the purpose of collective bargaining. So the government says workers have the right to join trade unions, but employers have the right not to deal with those trade unions. And it's all premised on this illusionary equality between employees and employers, whereas bosses have the cards here. If you don't work, you can't provide for your family. It's precisely why we have a situation whereby workers have historically combined, have won minimum wages, have won the weekend, have won 40-hour weeks and so on. That's why workers need to combine and act collectively. But the government says, don't worry, to employers, you can simply ignore, you don't need to engage with it. That's the purpose of this bill. This bill introduces mandatory trade union recognition so that when 20% of a given set of workers join a trade union, the employer is legally mandated to engage with that union through the industrial relations process. That's what it's about. It's very, very simple. It's about a basic element of democracy in the workplace. It's a measure that is supported by, in a recent Ireland Thinks opinion poll, 70% of people in this country. And it's to deal with a situation that, for example, take the second biggest company in the world, Amazon, owned by the second richest man in the world, Jeff Bezos, notoriously anti-union individual and employer. The richest man in the world, by the way, Elon Musk, also a notoriously anti-union individual and employer. There's a pattern there. But we know that Amazon is expanding in Ireland. They've now got 6,500 workers. That's going to be increasing even further. We know that they are renowned for poor working conditions. We remember them denying and then forced to retract on workers in America being forced to pee in bottles because they're not provided with appropriate breaks, toilet facilities, and so on. So a huge amount of wealth being made off the backs of massively exploited workers in poor conditions. But we have a situation currently where all of those workers in Ireland could join a trade union and Amazon could simply say, no, we're not dealing with you. This is a company that spends about $10,000 a day in fighting unions and trying to keep unions out of their shops. They spent over €10 million, I think, in 2022, 2023 in trying to defeat unionisation. And so we need to match the effort of those workers in Amazon in this country, fighting to build unions, to get organised, with a legislative framework that gives them the right to be in that union and then compels the union that if they go and it compels the employer that if they go and join a union, the employer actually has to deal with them. Thanks.
Thank you, Deputy. Deputy Ruth Coppinger.
So I think once again this is a bill that's had to be brought before the Dáil because the Irish government persists with this illusion that people have a right to union representation. You know, it's very Orwellian that you have the right to join a union, but your employer doesn't have to recognise it, so you really don't have a right. So if the government is serious about workers' rights, this is a key one. Now, in the early 80s, we had about 60% of our workforce in unions. Now we've 1 in 4. The trade union movement has largely become in public sector, actually becoming more female because women workers are very located in the public sector. There are now more women than men in trade unions, ironically. But the people who are being particularly ill-served are young people and migrant workers who also make up a huge part of our workforce. Over 2/3 of non-union members, however, aged 16 to 24, would vote to establish a union if they could. They're very positively disposed towards being in unions. Young workers are significantly less secure, more anxious in their work than older counterparts. 1 in 5 young workers are worried about losing their job, having a reduction in pay if they join a union, and half of young workers 16 to 34 are worried about a reduction in their pay particularly. Now, that was a survey that was done by UCD, and it really shows how positively disposed towards unions people actually are. However, they're not joining them, and I think there's a number of factors there. There's the anti-union culture that's pervading throughout particularly private sector workforces. And also, we have to say that the trade union leadership should be actively going out and recruiting workers in a much more serious way. So I think there's a few things that we should look at. A positive aspect of this bill is it obliges employers to further engage after recognition with workers on their wages and conditions. Unions have suffered extreme losses of membership due to the anti-union sentiment, particularly of American multinationals who come here, who are, if you like, consciously attracted here by our government, but yet there's a message sent out that you do not join a union, and if you do, you won't be tolerated. And that's a conscious policy as well by the government. There's also, I want to mention, an EU directive which the government hasn't implemented, entitled Directive on Adequate Minimum Wages in the Union, in the EU. It obliges governments to assist where less than 70% are covered by collective bargaining. The government is meant to make that easier, but it ignores this. And Owen Reedy, the General Secretary of the Irish Congress of Trade Unions, said the government voted for this directive in Brussels 2 years ago, but has ignored it and obfuscated in Dublin ever since. The directive is about the state being obliged to promote collective bargaining so workers and employers can negotiate in the workplace and at sectoral level to improve living conditions. And there's many other quotes from people in leading figures in the Irish Congress of Trade Unions about it, saying how unacceptable it is that the Irish government has not implemented that directive. I want to mention strikes for trade union recognition as well. I've been personally involved in supporting workers over many years on such strikes. So we've had companies like Aldi and Lidl who now proliferate throughout the country, who have a conscious anti-union policy. I would have supported workers young workers in Aldi in the early 2000s who joined the union on Parnell Street and were sacked. Now, of course, in theory, they're not sacked for joining a union because companies cannot do that legally. They find other means to sack them, you know, giving them work that they can't do, creating very difficult conditions. That's the modus operandi of companies. to flout our Irish law. And we know in the retail sector in particular, which traditionally in the past would have been very, very unionised because workers fought for those rights, there's a huge anti-union policy. And we have to say, not just by the Aldis and the Lidls, but by the two big private sector employers in this country, Tesco and Dunnes, who are long-standing trade union memberships, but the companies are actively not recognising the workers and their union. So one example in Tesco, again, I think it and Dunnes are the two big private sector employers. In December 2024, members of Mandate Trade Union launched public protests following Tesco management's decision to deny workers their right to be represented by their union and refusing to agree an adequate pay increase. What Tesco management are doing is they're refusing to collectively bargain, and instead they're imposing their own pay awards on the workers, not what the union is actually fighting for. And as an example of that, Tesco sales, not due to lack of profits, of course, profits rose by 10%, but workers only get pay increases of less than 4%. One of the Mandate reps said the company's actions can only be seen as a clear act of bad faith and textbook union-busting tactics. But I also want to mention Dunnes as well. It's an Irish company. It has a rotten tradition of dealing with the trade union and with the workers. We know that going back to the anti-apartheid strike, it has continued for 40 years to have this policy. And in 2015, Dunnes workers had to have a ballot, basically for the right to have their union engaged with by Dunnes. The company also refused, by the way, Minister, don't know how you feel about this, to recognise a Labour Court recommendation. Now, we all know Labour Court recommendations are not compulsory. Workers can reject them as well. But when workers reject them, we hear nothing but abuse in the media of those workers. It doesn't happen when it's employers. But it's actually quite incredible that Dunnes, and this is from December 2024, so this is very recent that this is continuing, Mandate urged the company to engage on outstanding elements of the comprehensive 2024 pay and benefits claim. And the 5% increase that they got was a win for the Dunnes workers. But listen to this, Minister. Mandate highlighted the lack of progress on paid maternity and paternity leave. A growing number of competitors in the retail sector have introduced paid leave for new parents, and Mandate believes it's time for Dunnes Stores to do the same. This is one of the biggest companies in this country, refusing to give particularly women workers, who are the huge percentage of their workforce, the most basic rights. And we also know that the whole last-minute contracts are designed to mitigate against trade union membership and recognition, because it's very difficult for a young worker or a new worker brought in on not knowing what your contracts are. We know that workers are not allowed on the shop, union membership are not allowed on the shop floor in many of these places. And of course, we also have to be realistic here. We want workers to join unions, but unions have to be fighting unions, because the Debenham workers were a highly unionised workforce, and look what happened to them, because they got no support from their union leadership, unfortunately. They had to do it all, self-organise themselves during a pandemic in a very difficult situation where the company had bolted and left them. And so, Minister, there's a whole number of things, and I've spoken about this before, that you need to do so that this doesn't happen to workers again, where they lose even their redundancy, never mind the paltry claim that was given to them by the courts. So we need fighting trade unions, and a lot of the union leadership are hiding behind the fact that there is anti-union laws. Anti-union laws can also be organised against. You know, the Industrial Relations Act, which is a significant impediment to workers having the right to effectively organise, can be breached and challenged. You know, that's what you do to get rid of unjust laws. And again, the Debenhams workers and others did it by having mass pickets, by going when the stock was being taken out of the shop. And I think it's absolutely critical that the trade union leadership make themselves relevant again in this era, because it's clear young workers want to join, it's clear migrant workers want to join. I'm assisting migrant healthcare assistants, as you know, who are joining Unite Trade Union, which is very, very positive to see that for migrant workers. But there needs to be a fighting lead given by all of the unions to recruit these sectors and then to actually represent them and to challenge unjust and anti-union laws and anti-worker laws that your governments successively have kept in place.
Thank you, Debbie.
Yeah. Colleagues, welcome the opportunity to discuss Government's position on this private member's bill and on the Trade Union Recognition Bill of 2021, which is scheduled for second stage debate. The bill aims to establish a legal mechanism for trade union recognition for workers who constitute at least 20% of the employees in an employment or any category within that employment. There's also proposed criminal sanctions for employers who fail to recognise and engage with the trade union. After careful consideration, the Government will oppose this bill for several compelling reasons. I wanted to outline the reasons why and the plans the Government has for strengthening supports for collective bargaining this year. Legal advice provided to Government since the bill was originally considered by the House outlines how this bill gives rise to an apparent breach of Article 40 of the Constitution, at least insofar as it proposes an employer being compelled to recognise and engage with the trade union under threat of criminal sanctions. Article 40 of the Constitution guarantees the right of citizens to form associations and unions. The Supreme Court has also held that there is no duty on employers to recognise unions. Any legislation which seeks to compel an employer to consult or engage with the trade union would therefore be a significant risk of being found to be unconstitutional. In addition, the bill fundamentally misrepresents the legal basis of the employment regulation orders, which are intended to be sectorial wage-setting mechanisms negotiated at joint labour court committees, not applicable to individual employers or trade unions. Certain sections of the bill, such as those related to unfair dismissal for seeking trade union recognitions, are already covered under existing legislation, specifically the Unfair Dismissal Act. It has been the consistent policy of successive Irish governments to promote collective bargaining through legislation and by the development of institutional frameworks supportive of a voluntary system of industrial relations that is the premise upon freedom of contracts and freedom of association. The 2025 Industrial Relations Act defines collective bargaining as comprising voluntary engagements or negotiations with the object of reaching agreement regarding working conditions or terms of employment or non-employment of workers. There is an extensive range of statutory provisions that are designed to support collective bargaining, and the freedom of association and the right to organise and bargain collectively are also guaranteed in a number of international instruments which the state has ratified and which it is therefore bound to uphold under international law. This long-standing tradition of volunteer system has served us well over the past number of decades. Ireland's attractiveness as an investment location and the basis for much of our competitive advantage has been due to the stability and industrial peace provided by our voluntary model of social dialogue. It has also fostered a stable and cooperative industrial relations environment and facilitated numerous successful resolutions of industrial disputes and the negotiation of collective agreements that have benefited both workers and their employers. The volunteerist system of industrial relations allows for tailored solutions that meet the specific needs of different sectors and workplaces, and by fostering a cooperative and non-confrontational approach to industrial relations, the volunteerism system has contributed to industrial peace and stability. The system is based on mutual respect and trust between employer and trade unions, and I believe that a strong and well-functioning collective bargaining system both supports productivity and fair wages, especially in low-paid sectors. To give one example, the 2024 sectorial employment order for the construction sector comes into effect on the 1st of August this year and will introduce higher rates of pay for both craft and general construction workers. Their pay will increase by 3.4% in August of 2025 and again by 3.2% in August of next year. And the sectorial employment order process is a statutory wage setting mechanism that provides for in the 2015 Industrial Relations Act and based on the principles of collective bargaining. In addition, last year 3 new employment regulation orders came into effect covering workers in the early years learning, in security and contract cleaning sector. These agreements demonstrated how effective the Joint Labour Committee system can be when representatives of employers and employees voluntarily negotiate together to identify a mutual beneficial agreement. Members will also be aware of the Directive of Adequate Minimum Wage, which aims to promote collective bargaining on wages in all EU member states. It sets out that each member state in which the collective bargaining covers rates is less than the threshold of 80%, as is in the majority of member states, including Ireland, shall provide for a framework of enabling conditions for collective bargaining and shall also establish an action plan to promote collective bargaining by the end of 2025. There is no obligation of member states to reach any prescribed level of collective bargaining coverage within any defined time period. A technical group was established in 2023 with the social partners to discuss collective bargaining, and Ireland's action plan has been meeting regularly and constructively. The capacity of our social partners to engage effectively in collective bargaining is also a key element of the directive, and I hope that the Government can further support the social partners in this area. This Government supports for collective bargaining is reflective in the Programme for Government, which contains a commitment to finalise an action plan on the promotion of collective bargaining by the end of this year. I am pleased that my department has held a public consultation process on the promotion of collective bargaining from the 14th of April to the 12th of May, and my department are now carefully reviewing the submissions received. It is intended that the consultation will help guide us finalise the proposals, bring legislative and administrative forward, which may be considered for inclusion in Ireland's action plan. And I want to make the process of finalising this action plan as open and as transparent as possible. I would also like to take an opportunity to highlight the many positive and progressive changes to workers' rights which this Government has introduced in recent years. These employment law developments have resulted in significant improvements for conditions of workers. Firstly, I would like to mention the legislation introduced in July last year, which provided for the establishment of the Employment Law Review Group. And this work has kicked off in January of this year when Minister Burke announced the appointment of the Chair and members of the ELRG. Since then, the inaugural plenary meeting of the group took place in March, and the group's work programme has been agreed and published on our departmental website. The work programme contains 3 items, including the determination of employment status, review of the Unfair Dismissals Act, and review of notice period in the minimum notice of terms of the Employment Act. The work of the group will be critical, important in the coming years, and it will also provide a unique, independent and expert analysis on our suite of employment rights protections. Another important development took place in January this year when the European Communities Organisation of Work Time Defence Forces Regulation Act of 2025 was signed into law. And these important regulations provide for the statutory protection of the Organisation of Work Time Act, which now applies to members of the Defence Forces. Looking back in 2024, the Employment Permits Act introduced significant changes also, including the introduction of a new seasonal employment permit, and this is a short-term permit which will allow non-EEA nationals to work in seasonal employment for up to 7 months per year. 2024 also saw the commencement of the rights to request remote working under the Work-Life Balance and Miscellaneous Provisions Act. In July of last year, we saw the commencement of the Employment Collective Redundancies and Miscellaneous Provisions and Companies. This Act amended the Protection of Employment Act to further enhance the protection of employees facing collective redundancies caused by employers' insolvency. Since the introduction of statutory sick leave in 2023, business owners, particularly in the retail and hospitality sector, have consistently raised concerns around collective impact of such measures in light of rising costs, input and security costs. We saw the introduction of the statutory sick pay, which marked a key policy development for Ireland. Originally 3 days, the entitlement was increased to 5 days in January of 2024. And recent research has shown from our department that firms in retail, accommodation and food services are likely to be more impacted should the statutory sick pay entitlement increase from 5 to 7 days. Following this work and in line with relevant legislation, statutory sick pay will remain at 5 days. Another piece of legislation which has had significant positive impact for workers is the Tips and Gratuity Act. This act has been in operation for over 2 years and obliges employers to distribute tips fairly and to prominently display the tips distribution for many of its employees. In relation to the wider work in this area, we are also significant development at EU level for my department to engage in work within the platform work directives, and we have entered into force on the 1st of December 2024, which will be transposed by the 2nd of December 2026. In conclusion, the Government will continue to protect the measures which have been put in place to support collective bargaining within a volunteerist industrial relations framework which has served the state well to date. It is also important to do this in a manner that is ambitious, balanced, legally sustainable and cognisant of the views of the public consultation that my department will conclude, and on the basis that the Government opposes this private member bill while reiterating our continued support for proactive engagement between workers, their representatives and their employers.
Thanks, Cathaoirleach, and I want to thank Deputy Murphy and Deputy Coppinger for bringing forward this important bill, and very timely. Minister, as a state, we're well behind other EU states in terms of the rights of workers to be represented by a trade union. Most other EU states, that's a legal guarantee, so we're completely out of line with most of the rest of our European neighbours. That right has been resisted by successive governments and big business down through the decades. While the Constitution guarantees the right to be able to join a trade union, an employer doesn't have to recognise it and can simply refuse that right, the right of staff to collective bargaining and the protection that union membership offers. And when we take that employers have greater social and economic powers than workers, that's just a simple fact. The only power that a worker has is through combining with their co-workers so as they can't be picked off individually, as a tactic that's often used, and I've witnessed it myself in workplaces. Hundreds of thousands of low-paid workers have no representation and very little rights. And if we take the percentage of workers in the private sector that are now unionised, it's very, very low at the moment, and that needs to change. The employment in many sectors has become casualised with no set hours. Short-term contracts are common, as is so-called employment agencies. Workers' rights in a lot of cases have gone backwards, and that needs to change. Hard-won basic rights have been undermined by union busts and activities. Workers who join a trade union are sometimes targeted by their employer and victimised, and there are good examples of that around the state. One group of workers will be pled off against another, which is common practice, and in some cases unionised workers will be cleared out of a business and replaced with in a relatively short period of time with lower paid, non-unionised workers. And that can be seen around this country where that is happening. The beef industry and some beef plants, that happened. So while previous government ministers have stated that they fully support the right of any worker to join a trade union and be active in their trade union, they're hollow words. It doesn't have any meaning because you can't bring it into effect. And workers will tell you that. And if you talk to workers about joining a union, they'll express a fear in a lot of cases of being targeted by their bosses over being a union member. And could I ask you this? Could you imagine the uproar if members of IBEC were told by government or the Hotel Federation or the IFA or other organisations which legitimately have a right to collectively negotiate with government, could you imagine if they were told by government that they can't represent their members, that you only deal with one or two of them individually? There'd be an uproar in this country. So it's time to close the loophole in Irish law. It's time to bring industrial relations into the 21st century. It's time to catch up with our EU neighbours. And, I heard your words that the government have committed to bringing in collective bargain. I would ask you not to backpedal on this. Put your foot on the accelerator and drive this on. We need to move into the 21st century with industrial relations in this country. And I appeal to all TDs to support this good bill. Thank you.
Thank you for the opportunity to speak on this bill, and to Deputy Murphy and Deputy Coppinger and their staff for bringing this very important legislation forward. I support this bill and its intention to provide mandatory union recognition where 20% or more of the workforce are members of a union. Union representation is extremely important to ensuring that union reps have access to their members' places of work, and this is vital. It's also important that unions are able to negotiate with employers on pay, hours and conditions. Sadly, this isn't always the case in Ireland, as employers have no obligation to even acknowledge trade unions. We've seen examples of many employers who fail to engage with trade unions at all, which is just totally unacceptable today. Most of the private healthcare sector do not recognise or engage with trade unions. We all know examples of big companies in this country who refuse to recognise trade unions for collective bargaining. I will not name and shame, but it's not hard to find reports of companies with hundreds of employees that are not recognised because there's no union recognition, nor is it hard to find people with negative experience of trying to get their employers to recognise unions. I myself have personally had experience of employers failing to recognise or engage with trade unions in the past. Trade unions offer numerous benefits to their members and are often so needed in purpose of negotiation and representation. A union can make significant difference when fighting for fairer and better conditions for workers to access legal protection and workplace disputes, as well as accessing financial resources. Workers have the right to be represented. We all know the value of trade unions, and I think many of the situations, the presence of a trade union rep is crucial. Union reps, healthcare workers have been instrumental in reaching agreement with the HSE and the WRC over staffing and recruitment. They demanded changes to how staffing vacancies in the HSE were reviewed, and also called on the Health Service to accelerate the recruitment process for vacant posts. Unions representing the firefighters in Donegal have been vital in fighting for adequate resources and accountability. Workers have the right to organise and be heard. It is shocking that Ireland remains one of the few European countries where no right to union recognition is seen. This needs to change. It is a change that the government has to process, and if the government progress this bill, I'm urging you to do so.
Garmagad, I want to thank the deputies for bringing forward this really important PM.